pieces of either real estate or assets that somebody has. So with our topic today, I'm going to focus a lot on the home, but there are other things as well that can be planned around with long-term care expenses. Just a couple reminders before I go too in depth into detail on things, but if you're participating in this webinar, you do have the option to send in questions. So I will be able to see those come in through the Q&A box if you want to submit things as I'm going through things. So please feel free to do that. And then at the end of this, you'll receive an email with a couple materials from us. So one is our little graphic on planning around the home and some risks with certain things that a lot of people try to do when they're protecting their home, and some of the pitfalls of that. So I think that's a really helpful tool, at least to remember a lot of the things that can go wrong if you plan around the home in a way that maybe is less protected than you think. And then you'll also receive a form at the end of this where if we talk about anything today that raises concerns for either you or a loved one who may need care soon, and you want to talk to one of the attorneys in our office about planning around that expense, then gives you a place to let us know that you'd like us to reach out to set up a time to meet with one of us. Those are complimentary initial consultations. They don't cost you anything to come in and sit down and talk to us initially. Usually at the end of those consultations, which we schedule for about 2 hours, we can give you a pretty good idea on what the planning would cost. So, but please, if anything we talk about raises those concerns, let us know that you'd like to come in and talk to one of us. Okay, so getting started. The topic of this webinar and the question that we posed at the beginning of this webinar is, can the nursing home take my home? And so I think there's a couple big misconceptions to clarify around that question. First and foremost, it's not actually the nursing home that is taking the home. Nursing homes can't require you to sign over the home. They can't just take it from you if you're the moment you go in. So that's not really what happens. What people are really referring to is nursing home expenses or long-term care expenses are expensive. And so it can be something that they need to sell to help pay for care potentially. Or if they're receiving Medicaid assistance, Medicaid can attach a lien to that property depending on their circumstances, where at some point that lien may eat up the equity. But even then, they can't take the home until after the person has passed away potentially too. And even then, that does depend on the circumstance. So it's not a guarantee that it will be recovered by Medicaid, but it is where most people are talking about that nursing home expenses taking the home. So yeah, it's really not the nursing home doing anything there. They're just charging for their services, right? And it's expensive care. And so people often have to try to financially plan around how do we pay for these expenses. But protecting the home from Medicaid spend down or from Medicaid estate recovery is still a valid concern, right? It may be a family asset that's been around for a long time, or it may be the main source of your estate that wealth that you're passing on to the next generation. Maybe you have someone you care about that you're trying to plan for them, right? And protect them financially with the value of the home. So there's valid reasons to still try to protect the home, even though it's not the nursing home themselves taking it, it's more around Medicaid benefits. So when we're talking about how, when the home may be at risk for Medicaid spend down, there's really two really big things to remember. And that's that it matters a lot whether you are married or single and what other assets you have available. So if you're married and one of the spouses, is still living at home, if they don't need care, as long as it's the primary residence and of that person, they do not have to have a lien attached to that home by Medicaid. They, the healthy spouse gets to stay in the home. They do not have to sell the home to pay for their spouse's care. It is not recoverable after that first spouse passes away. So the healthy spouse still gets to maintain the home as long as they themselves don't need care at that same time as the other spouse. So that's less of a concern than anything else. But where it can become a concern still is if both spouses end up needing care. Because if both spouses end up needing care, then there is no exemption where that home is not an available asset for both spouses. It is an asset where Medicaid can place a lien on it. unless there are a few other exceptions that are met, such as if there's a child with a disability living in the home, or in some circumstances, an adult child who was a caregiver, but that's a very narrow exception. So there are still exceptions even when both spouses need care, but it is generally an available asset if both of the spouses are in need of care and are receiving Medicaid assistance to pay for that care. When you're a single person, single individuals, that home is an available asset the moment they start receiving Medicaid assistance, right? When they apply for Medicaid benefits, they'll look at all that that person has and say, as a single person, you have this much in assets, it's all available. And here is, we're going to start placing a lien on it as we provide care. And that's when they can recover against the home after that person passes away through a process called estate recovery. So estate recovery it's not even, during lifetime Medicaid that they're going to take the home again. It is estate recovery where they file a claim against the estate because they have a lien on that property or a claim against the estate for the care they've provided. Depending on how much care is provided, they still may not recover against the entire estate. So if somebody only received Medicaid assistance for a couple months, and the home is worth, $300,000, it's very unlikely that that's somehow going to, at the current rate of care anyway, going to eat up all of the equity in the home. It might be a lien of, $20,000 potentially, depending on the cost of care, but not the entire value. So it is not an immediate thing that all of a sudden there's an entire lien against the home. So with trying to protect the home, though, there are certain things that you need to be very aware of that can cause a lot of issues too. One of the most common questions we get is, should I put the home in the kid's name? Most people, when they're talking about that, are familiar with the 5-year rule for Medicaid. The 5-year rule is the 5-year look back, where when you apply for Medicaid benefits, they will look back the previous 5 years to see, did you give anything away? Did you sell something for less than fair market value? Did you try to, hide the asset in any way where it suddenly wouldn't be available for care? And if you did that within the 5 years before that application, the date of that application, they'll give you a penalty for that divestment. And that penalty is a period of time where they won't provide payment for your care based off of the value that you gave away. So if you give you an example based off of the current rate, the divestment rate, it would be somebody gave about $93,000 away roughly. That would be about 10 months that they wouldn't provide payment for care at the current rate. So that changes every year though. But when people ask the question about should I put the home in the kid's name, they're often aware of that and say, well, if I give it, to them 10 years before I need care, is that a good idea? And there's still a lot of concerns when you gift the home to children directly, when you put it directly in a family member's name other than yourself. And there's really 3 big concerns with that. First and foremost, it's a huge loss of control over the property. I hope everybody trusts their kids enough that their kids wouldn't evict them or charge them rent or, sell the property without their permission. But this is the kind of loss of control that can occur if you just transfer the home over to somebody else. It sounds awful, and morally speaking it is, but from a legal standpoint, you no longer own the home then, and that individual may have the right to, sell the property, evict you, charge you rent, whatever. So it's awful from a moral standpoint, but from a legal standpoint, it is something that somebody could potentially do once the home is transferred over to them and you no longer own it. So even if that's not a concern though, and again, hopefully it's not, but if it is, something to be aware of. But even if it's not a concern, there's really 2 other big risks with gifting the home directly to the kids or transferring it directly into their names. The first is, an issue of taxes. So the actual transfer to them itself won't necessarily create a taxable event for them where they'll have to, file it on their taxes and show an income or anything like that. But it could create a tax issue years down the road, potentially, when they have to sell that asset. So when you paid, for your home initially, the price of that home, and this is a very watered down definition, but for simplicity's sake, I'm going to water it down. When you buy your property, your home, the IRS says you have a cost basis in that property, which is essentially, what did you pay for the home? If the home was worth $350,000 and you paid $350,000 for it, whether that's through down payment or, a loan or whatever, that's your cost basis in the property. Cost basis is how the IRS will determine if there's a taxable gain or loss later on when that property is sold. So if you sold your home for $400,000 after buying it for $350,000, there'd be a $50,000 gain, right? Now, the good news is that when it's your primary residence and you've lived there for 2 of the last 5 years, if you sell your property and there's a taxable gain on it, you have an exclusion, of taxable gain of up to $250,000 per person, per resident of the home who actually owns the property. So not like minors. But so if you're married, that could be a $500,000 exemption from gains, right? However, when you are not a resident of the home, so if it was like a secondary property, if you own, investment real estate, for example, that exclusion does not exist because it's not your primary residence anymore. So, and you can only have the one primary residence. So when you gift the property over to the kids, if there is that taxable gain, they'll have to pay capital gains tax on that sale. The biggest reason that gifting that property over to them or transferring it without them buying it from you for fair market value, the reason that creates a big issue is when you do that, the IRS says, all right, whatever you paid for the home, we're going to say that's what they paid for the home, not the current fair market value rate. So this becomes a big issue for a lot of people when they many years ago bought the home, maybe, in some cases 40, 50 years ago, and they now gift it over to their kids at, in 2022. Well, if that happens, it's worth to the kids whatever it was worth to the parents, meaning it might be, maybe they paid, $10,000 or $15,000 for the home at the time, and which maybe is incredibly low. But today it's worth $150,000. That would be a big difference between the fair market value and the cost basis. So the better way to transition that type of asset to the kids is through inheritance, because when it's a part of your estate that you're leaving to somebody, you get an adjustment of cost basis up to fair market value. So then when the kids inherit it, it's worth the fair market value to them. And if they sell it for that rate or relatively close to that rate, it's very unlikely that they're going to have capital gains tax at all, if at the very least, maybe a small amount. So it is much more tax efficient for them to inherit that property than it is for you to just sign it over to them during lifetime. So I know that doesn't protect the asset from care, but if your concern is one of taxes, if you never needed care and they just end up paying a lot of taxes on it, that ends up being a problem for them. And it's just incredibly tax inefficient. Where my biggest concern comes in, though, with just transferring the home over to the kids is where liabilities start to become a concern for the owners. When you look at assets that somebody owns, what happens to them as an owner happens to the property they own. So if you own a property and you get sued, if you file for bankruptcy, if you get divorced or pass away, right, it happens to those assets. Now, when it's your primary residence and it's you and your spouse living in there, if you guys file for bankruptcy, get sued, there are some levels of equity protection in those cases so that you can't necessarily lose all of your equity in the home. It's not unlimited and it's not, airtight, perfect 100% value protection, but it is better than not having it. However, when you transfer that property over to non-residents of the home, and potentially, if let's say you had 4 kids, you've now added number of owners to the property too, as opposed to the original 1 or 2 that maybe owned it. Those liabilities of those people will also attach to the home. Well, if your children file for bankruptcy or get sued or get divorced or pass away unexpectedly, that will also happen to the asset that you've gifted to them, and that's in their name. So what you don't want to do is potentially protect the home from your long-term care expenses and just open it up to other liabilities in exchange, because that's not necessarily good planning. That's going to create just as many issues. But even if liability issues aren't a concern of the original owners of that property or of the people you've gifted it to, there can be concerns if one of those owners passes away. Does it match your estate planning intent? If your son or daughter passes away that you've gifted the home to, is that who you would want to inherit it? What if it's a spouse? Do you like that spouse? If it's a child that they leave those assets to, and that child has a substance abuse concern that you didn't know about, those sorts of things can be a huge concern when those people just inherit those assets, which is what would happen after you transfer that property over to somebody, because now it's theirs and their own assets are subject to their own estate plans. So no longer are they subject to your will or your trust or whatever estate planning document you're using. They're subject to that person's estate planning tools. So be very careful when you're talking about protecting the home that you don't create more liabilities for yourself or more risk for yourself in your assets than previously even existed. So there are ways, though, to still protect the home without those concerns. And generally speaking, when you're trying to protect real estate from long-term care, costs, it's much better to look at what's called an irrevocable trust for that. So with an irrevocable trust, you're still subject to the 5-year rule. You still want to try to do this in advance if you can. But once it's transferred over to that irrevocable trust, you can't be the trustee of it. Maybe it is the kids. But the reason that is safer is because those trustees, if that trust is drafted properly, you have what's called an occupancy agreement, which says that, they can't charge you rent or they can't sell the property without your permission, as long as you continue to pay, the upkeep and expenses, property taxes, things like that you've already been paying. So you have a lot more protection from somebody kicking you out of the home against your wishes or charging you extra to live in your own home. With that occupancy agreement, if it's drafted the right way, they can't do that. And again, you wouldn't want your kids to even, if you had those concerns, maybe don't gift it to them anyway, and maybe they wouldn't even be good trustees, but still you want that protection just in case. The second benefit is the one of cost basis. The irrevocable trust is still part of your estate plan. It's still part of your estate when you pass away. So that means that the kids still inherit the property at fair market value rather than having a cost basis from the 1960s, right? So that is a huge benefit for the beneficiaries of that trust. And then the third, of course, is the children as trustees. If they have something that goes on in their life, like they're getting a divorce or filing for bankruptcy, that doesn't happen to the trust. They don't own those assets yet. So it's a much, much safer alternative when it comes to issues of liability. For the beneficiaries, if when they're inheriting, there are concerns about responsibility or substance abuse issues, or somebody's filing for bankruptcy right when they're inheriting, right? Those trusts, if they're drafted properly, will have protection triggers in there that say things like, if this is happening to a beneficiary, then they can't be in charge of the assets, especially if substance abuse is a concern. If they're in the middle of a bankruptcy, then it's unavailable for their bankruptcy creditors, right? So those documents can have those protections in them, but it's very important to make sure that you have those in there in order to protect the beneficiaries. When you just transfer the property over to other owners, those protections don't exist. It's fully available to their liabilities, or once they pass it on to their kids, the kids' liabilities, grandkids' liabilities. So you can absolutely protect the value of the home through proper legal planning. You just have to make sure that you're not causing other issues as well when you do so. One big caution I would have too is that in 2014, the rules around Medicaid and Medicaid estate recovery in Wisconsin changed. So a lot of people bring in what's called a life estate deed and ask if they're protected. Did we protect the value of the home from estate recovery? And it used to be that prior to 2014, if somebody had a life estate deed, which a life estate deed, if you're unfamiliar, is you retain the right to reside in the property, but you transfer, the as you get older, you have less and less of ownership of the property, and maybe the kids have more and more. So eventually you have very little ownership and the kids have more by the time you pass away. And it also transfers the home to them after you die in full. So prior to 2014, those were unavailable for estate recovery. They protected from care after the 5-year look back, all of those sorts of things. There were always tax issues with those potentially, or just flexibility issues with those. So even prior to 2014, there were still some concerns with them. But the issue is post August 1st of 2014, Medicaid can actually, if it was drafted after that point, if you have a life estate deed from, September 1st of 2014, for example, or any point after August 1st of 2014, those rules now say that Medicaid can recover against that, some of the interest of that life estate deed after you pass away. So they're just not as effective tools even as they were before. And even before there were some, just flexibility concerns about them. So life estate deeds, if you have one post August 1st of 2014, it is still potentially available for estate recovery, at least your interest in it is. But if you have a deed prior to August 1st of 2014, a life estate deed prior to 2014, prior to August 1st of 2014, that has been grandfathered in. So it's not, it isn't subject to those new rules, but it's still, you may still want to do some additional planning for some further protection as well. But yeah, be very cautious about anybody trying to talk to you about a life estate deed now, because it just is not good planning anymore. And it is not as protective as some people think it is. So be very careful with that. So when we're talking about protecting the home, there can be a couple key reasons for this. Primarily it's not just to pass on assets to the next generation, but also to make sure that if you need, let's say, for example, you have the home set aside, the value of it's protected. Well, what happens if you have paid privately at a facility down to the point where now you're on Medicaid and that facility goes out of business, or you need to move to a new facility for new care needs? Well, if you don't have money to pay for that, that could be a really big issue. And your options with where you go at that point might be very limited. So having the value of this home protected, it's not just to protect it for the next generation, although that is a benefit. It's also to make sure that the original owners of that property have some flexibility in the quality of care that they receive. Maybe they want something that the care won't, Medicaid won't provide, like maybe not going out to eat with their friends once a week, or, maybe they're a big, movie lover. They love to go out to the movies, right? I mean, it can be things like that potentially the facility doesn't provide and Medicaid doesn't pay for as well. So that's the value in protecting it. We talked a lot about the home, but this can also apply to other assets as well. Protection of assets can be kind of across the board if you really need it to. So I do want to go through a couple other things of what it would look like if you were married or single and needed care, what would be available and what wouldn't be, just so you have some background on that. So I did talk about the home, both married and single. So again, married, the primary residence, as long as one spouse is living in it and not in need of care, is protected from availability. It's unavailable. But if you're married and one of the spouses is healthy, there are also other things that community spouse, the one living at home, still gets to keep. So the community spouse gets to keep the home, as I mentioned. They get to keep any IRAs, 401ks, 403bs, Roth or traditional, that are in their names. So this can be very good or very bad, depending on which spouse needs care first and how those assets are allocated. But if spouses are relatively equal in those assets, then they're both pretty well protected. Unfortunately, a lot of times it's one spouse has a lot more than the other. And if that spouse needs care first, there's more at risk. Because the spouse who needs care, their IRAs are subject to their care expenses. The community spouse can keep life insurance of not more than $1,500 total in face value. If you have more than that, which most people who have life insurance do, they'll look at any cash value as an available asset. You can keep a car regardless of value as well, and prepay your funeral expenses up to about $15,000 per person. And other assets, so regardless of whose name they're in, other real estate, joint or individual bank accounts, joint or individual non-qualified investment accounts, or just like a mutual fund, life insurance cash value over that certain point, the community or the spouse in care, their IRAs, 401ks, those are all countable assets. They add up the value of those assets, Medicaid being they, and they say, all right, we're going to divide that in half, the value in half, and that half has to fall either between $50,000 or at most $138,000 roughly. So if your half of the available assets is $500,000, you're not keeping $500,000. That community spouse still has to spend through those available assets down to at most 138 at current value. $50,000 is the floor. So that means if you have already less as a married couple than $50,000 in available, you're already Medicaid qualified if one spouse needs care potentially. If you fall within that range, that's when they say, all right, you keep whatever that half actually is. So the community spouse is not forced to spend down through everything. They are allowed to keep certain assets, and potentially with their IRA and the other assets that they get to keep could still be a couple $100,000. But if you're a single person, again, the only unavailable assets for a single person in need of care are, again, the life insurance of no more than $1,500 face value, the prepaid funeral up to about $15,000, a car, and about $2,000 in assets. So a single person can keep a lot less than a healthy married spouse could. In terms of income, all of the spouse who's in care, or the single person who's in care, all of their income has to go towards the cost of care, except for $45 a month that they get to keep in terms of personal needs. The healthy spouse, the one living at home, can keep all of their income, which again can be both great or bad depending on which spouse has more income coming into them. If the healthy spouse living at home has less than about $2,900, $2,800 a month, they get to keep enough of the spouse who's in care. They get to keep enough of their income to bring them up to that as close as possible. So it could potentially be all of it, depending on where they fall with both of their incomes combined. But if they're over the 2,800, they're not keeping any of that spouse's income. They're only stuck with whatever they have. So again, it can be a pretty big life change for those people if they were used to living off of higher expense, more of a budget every month than $2,800 if that's where they're at. But if you're single, again, you're only keeping that $45 a month in income. So it's not a whole lot to pay for things that Medicaid doesn't already provide for you payment wise, or the facility's not providing for you. So this is where supplementing that with potentially setting aside certain assets can be very important. Another huge benefit that I didn't mention earlier, and just as I'm running a little low on time here, I want to mention is with irrevocable trusts, those are also exempt from estate recovery. They're not available for that. So if you have set up an irrevocable trust and you have your home in that trust and it's been made it through the 5-year look back, no issues, things like that, maybe at some point you need Medicaid assistance. Even if Medicaid has provided assistance, they cannot recover against that irrevocable trust. So it's protected from that as well. But with that, I'm not seeing any questions. So just a reminder to everybody, keep an eye out for that email. You'll receive the home graphic we have here on protecting the home, and our feedback form where you can let us know if you'd like to set up time for an initial consultation. Again, those are complimentary and they are scheduled for about 2 hours. Sometimes they take a little less, sometimes they take a little more, but depends on how in-depth the conversation goes. And then next week, we actually have another webinar at the same time on, do my kids inherit my debt when I die? Do I have to worry about that? So that's a very interesting topic as well. So I would encourage you to listen to that. I won't give too much spoilers on that, just so that maybe I can encourage you to watch it. And then the week after that, we have our public seminar, which if you go to estateplanningAppleton.com, you can sign up for. And please feel free to do that. The sooner the better, just because sometimes seating can be limited. So that's where we talk a lot about wills and trusts as overall tools and sort of the general estate planning topics, as well as more general long-term care planning strategies as well. So with that, I will let you guys go and enjoy the rest of your day. Thank you for joining me, and I hope to see you guys